Welcome to Talking Legal with TEMPLARS. My name is Dayo, Okusami, I'm a partner in the firm. Today I have my partner with me, Godwin, Omoaka, Senior Advocate of Nigeria. He's in our dispute practice, and we're going to be talking arbitration and judicial intervention in arbitration. Godwin, thank you for joining us today.
It's a pleasure, Dayo. Thank you.
So, can you just give us a broad overview of, we know what arbitration is, but what are the issues and contexts regarding what is judicial intervention in arbitration?
Well, judicial intervention simply means that the ability of the court to intervene in the arbitral process.
Okay.
And that intervention could be either in support of the process, and that is generally, or against the process if it is being used in a negative sense, all right? But the general provision of the law is that based on Section 34 of the Arbitration and Conciliation Act, a court should not generally intervene in the arbitral process, except in the instances where the Act itself has specified. And this will include cases where there's going to be an appointment or removal of an arbitrator,
Yes.
cases where the arbitral tribunal needs to take evidence,
Okay.
and then the court is called upon to assist in compelling a witness to appear before the arbitral tribunal.
Yeah.
Cases involving where there are going to be a recognition or enforcement of the arbitral award,
Yes.
or again in cases involving setting aside or lack of enforcement of the arbitral award. So these are the clearly defined cases in which a court is allowed to intervene in an arbitral process. Other than these cases, a court is not allowed to intervene. Then one last one.
Yes.
Cases in which the court will have to grant an injunction
Yes.
in aid of the arbitration. Perhaps somebody wants to get an injunction, a quick remedy,
Yes.
and the arbitral tribunal is not constituted. One of the parties can quickly rush to court to get an arbitral award. So this is what is meant by judicial intervention in the arbitral process.
Okay, Godwin, thank you for that. So you've given us a broad overview of judicial intervention in arbitration. Let's go in a little deeper now. What roles have the Nigerian courts played, factually speaking, in arbitration to date that you would care to elaborate on?
Very important question, Dayo. Let me begin by saying that there is a misconception, right? That the Nigerian courts have not been supportive of the arbitral process. That is clearly wrong. The statistics we've seen lately, and I mean, this is thanks to the work that TEMPLARS has done in this area.
TEMPLARS did a TEMPLARS Arbitration Report of Nigeria.
Yeah, the
Yes,
TEMPLARS
correct.
Arbitration Report of Nigeria. What that data clearly showed us is that the Nigerian judges understand arbitration. The percentage shows that the courts have been pro-arbitration. They've really supported arbitration.
Yes.
And more often than not, contrary to the perception, like I said, that is out there, the judges are actively promoting the use of arbitration, right? A lot of the judges are also trained in the use of arbitration. So our courts have really been pro-arbitration. That is not to say that you won't find cases in which the court has, contrary to what the law says, intervene in arbitration in a manner that is not consistent with the law. And in most of those cases, you find that the parties that are involved are mostly state-owned parties, government agencies and government entities.
Okay.
And as the time shows, that is where I think we need to do a little bit of work in terms of getting the courts to support the process the more, where government agencies or state-owned entities are involved in the arbitration process.
Okay, thank you. That's an important point, because TEMPLARS did a TEMPLARS Arbitration Report of Nigeria where we spent time going over years of data to determine whether there is broad-based support of arbitration in Nigeria, and the results shown what you've just said. The report's also shown that when the courts do push back against arbitration is usually when there are awards that are adverse to the Nigerian government or its state-owned entities. So you're saying we need to look at that to ensure that there is more transparency in that process.
Absolutely.
Okay, thank you for that. Now, and it's a good point that you've cleared, because there is a misconception. I'm a lawyer, but I'm not a disputes lawyer. I have the misconception, which you've corrected, that generally speaking, the Nigerian commercial and legal environment doesn't support arbitration. You're saying that from your experience and the data we've analyzed over the last 20 years, it in fact does. That's a good point to put aside. Okay, so please let us know some more regarding your thoughts regarding elaboration of this judicial intervention with arbitration.
Well, generally, like I said, the courts are only to intervene in those specific instances that have been listed in the Arbitration and Conciliation Act. For instance, an arbitration in aid of, for an injunction in aid of arbitration, under Article 26(3) of the Arbitration and Conciliation Act, where cases where a party intends to either appoint or remove an arbitrator. So, for instance, perhaps as a result of the appointment mechanism in the arbitration agreement, there's a deadlock. The parties are not able to agree on either the identity of a one-man arbitration panel or on the presiding arbitrator in the case of a three-man panel.
Okay.
Then the law allows you to go to court for the court to appoint either the arbitrator or the presiding arbitrator in the case of a three-man panel in cases where the parties are not unable to reach an agreement. And typically the court will do that based on certain procedures that have been specified in the Arbitration and Conciliation Act. And this is also the same, both for local and international arbitrations, as well. International arbitrations, at times, it's institutional. The parties will say that an institute like the ICC, the London Court of International Arbitration, may do the appointment. Then the court supports the process again when it comes to evidential issues. For instance, an arbitral tribunal does not have coercive powers. It cannot compel a party to appear before it to testify.
All right.
Yeah. So if the party wants to testify and you want to get a party to appear before the tribunal to testify, then you have to approach the courts to say that, look, I need for Mr. A to appear before the tribunal.
So the issue is subpoena?
Yes, the issue is subpoena.
Oh, really? Okay. Yeah.
The courts issue a subpoena to compel the individual to testify before the panel.
Okay.
The arbitral panel. So that is another instance in which the courts play a critical role in the arbitral process. Then, of course, the most common instances we find are when it comes to either setting aside award or enforcing.
And I want us to talk about that.
Where a party is either aggrieved or unhappy with an arbitral award, they approach the court to set it aside. And that's where we have seen a lot of judicial intervention have raised a lot of conflicting issues and debates over time.
So, Godwin, now you're getting to kind of the meaty part, because, again, very long time ago, I was a litigator, and
thankfully you're not now.
Thankfully, I'm not. Thankfully, I'm not a litigator anymore. But I remember people going to arbitration, because I tried to be an arbitrator as well. And the question that often arose is, what's the point of going to arbitration if someone at the end of it goes to court? It defeats the whole purpose, and it just challenges the confidence you have in arbitration. And you mentioned that. Can you elaborate a little bit more on that? What's going on in the Nigerian environment? Contextualize, and what can we do to improve the situation?
Very important question, Dayo. Like I said, many a times people get an award from an arbitral tribunal and one party is dissatisfied, right? Now, under the Arbitration and Conciliation Act, Section 29, Section 30, a party can approach the court to set aside an arbitral award on the grounds that have been listed.
Yes.
So
very specific grounds.
Specific grounds.
Okay. Not that I'm unhappy I lost.
Yes. Not that you're unhappy you lost. There are specific grounds. Because don't forget, an arbitral award is final and binding on the parties.
As it should
so
be.
there is limited scope for intervention by the courts or for setting aside. And that limited scope is what the courts are, is what the Arbitration and Conciliation Act has tried to delimit in sections 29 and 30. So oftentimes what you find is that parties go to court to approach the court to set aside an arbitral award. Many often than not. There are so many grounds you can use, but chiefly misconduct.
Yes.
Where the arbitral award, where the award is beyond the scope of the submission of the parties.
Yeah.
And misconduct is a very broad and generic term that has been defined in a lot of cases, chiefly I would say the Taylor Woodrow case. But the point is, because of that, we've seen that our courts have been increasingly been saddled with inundated with cases where parties seek to impeach the credibility of an arbitral award.
Yes.
But thankfully, like the statistics showed, our courts have actually rose up to the test, to the challenge. Yeah. They've enforced more than they've set aside.
Okay,
right?
so you're saying the challenges have been enforced more when they go to court than set aside.
Yeah,
okay, that's an important point. Yeah.
But I think the one drawback you will take from that is the fact that the initiation of the process itself leads to delay.
Correct, which defeats the purpose of going to arbitration.
Almost, not defeats,
but
almost.
It's a hindrance to the process.
It's a hindrance. Yeah. Because in a way, there has been like a judicialization of the process, because a party gets an award in its favor, the aggrieved party is dissatisfied, approaches the court to set aside, and then the court either refuses to set aside, then he appeals to the Court of Appeal. 5 years, 3 years, he appeals to the Supreme Court. So I think that is where the challenge is.
Yes.
And right now, one way we are looking at addressing that challenge is that there is a current arbitration bill before the National Assembly, which is looking at how it can really close that loophole by setting up a special appeal panel in relation to arbitration under the Arbitration Conciliation Act, right? So that's one suggestion that has been mooted, and I'm sure that's going to be dealt with, or in a way prescribing a time frame for all of these challenges to be dealt with. Okay.
Godwin, thank you very much for that overview. This has been pretty interesting. I think we're going to need to have you back to speak on other issues.
It's my pleasure to come back.
But I think key takeaways are we've understood what judicial intervention with arbitration is. We've had a context of how it applied in Nigeria based on some work we've done at TEMPLARS with the TEMPLARS Arbitration Report of Nigeria and the data analysis. We've seen that while the narrative might show that the Nigerian legal environment and judicial environment is not conducive for arbitration, we've seen that judicial intervention has been minimalized, and actually when losing parties in an arbitration, to be blunt, approach the court to set aside, more often than not, these arbitral awards are upheld
by the court,
more than set aside, which is important for investor confidence and commercial confidence in the arbitration process in itself.
Very important, because before now, until that report came out, which is very critical, and I've had arbitration practitioners and users meet me and interact with me at various fora, and they cannot thank TEMPLARS enough for that data, because what that shows is that it builds confidence in investors to come into this country. Because before then, the perception generally was that Nigeria was not pro-arbitration.
Right.
Especially with the global gas case that came up about 2 years ago.
Yes.
There was a whole lot of noise about the whole global gas case.
Correct.
Right? Yes. And then it put Nigeria in a bad light as well.
Yes.
You know, so I think I wrote an article on that case. So, but I mean, the specific statistics that we gave, the data that we put out there, showed that really that is not the case. And I'm happy that arbitration practitioners, users I met recently at a conference in
Istanbul.
Istanbul, yes. You know, I had to ask for me to send them copies of the TAR because of the importance of the report, because now they have an empirical data upon which they can say, oh, Nigeria is more pro arbitration than anti-arbitration than we thought. Yeah.
Correct. Okay. Well, Godwin, thank you for that. Ladies and gentlemen, you heard it from the senior advocate himself. We talked judicial intervention with arbitration in Nigeria. This is Talking Legal with TEMPLARS. Thank you for your time. See you next time.